DTS Attorneys is here to guide you through the process of administering a deceased estate, and I've been joined by Monique here, who's just going to guide us on what the process entails. Monique, do you mind just explaining what it means to wind up and administer a deceased estate?
Well, it's called the winding up and the administration of a deceased estate. But what it basically boils down to is closing the financial matters of the deceased and then distributing the estate in terms of either the will or the Interstate Succession Act.
Okay, what would be the first step in the process if a family member or someone close to you has passed away and you want to get started with administering the estate?
Well, the first thing that you are going to have to do is to collect all the important documentation and information. So that would be the death certificate, the ID of the deceased, policy documents, bank statements, motor vehicle registration papers, all of that which will effectively then be needed to start with the administration of the estate.
Yes, we recommend keeping those files in order and making sure you have an emergency contact of someone who knows where to locate them, especially when it comes to policies you've taken out that could be difficult to confirm whether they exist or not if you're a different person who wasn't aware of them necessarily. It'll make life a lot easier for your family members after your passing. And then once these documents have been gathered, what would you do there?
Well, the family will usually contact us. We will then set up an appointment. We will then go through the documents to make sure that we do have everything to then report the estate to the master's office.
Okay, once the estate has been reported to the master's office, what steps do they take?
The master's office then obviously goes through all the reporting documents that has been submitted, and they will then issue either a letter of executorship or a letter of authority depending on the value of the estate.
Okay, and how would creditors be involved in this process?
There is a notice that is published. It is published in both the local newspaper and in the Dunman Gazette, where it will then call upon all creditors and debtors of the estate to either they settle the debt that they have towards the estate, or then to say the estate owes them a specific amount of money. This notice then gives the debtors and creditors 30 days in which they must then do that. And in that period, we will then also be contacting the known debtors and creditors to find out whether there is still anything outstanding or anything being due to the estate.
Okay, and among these debtors and creditors will impute the bank accounts the deceased has?
That is correct.
Okay. And then once these bank accounts have been closed and all the claims have been received, what would you do as DTS Attorneys?
Then the next step is to prepare the liquidation and distribution account. The liquidation and distribution account is basically a list of assets and liabilities in the estate, and it also sets out how it's distributed in that distribution part of the account. And that account will then go to the master. Another notice will then be published again in the local newspaper and in the Gazette, indicating that the liquidation and distribution account is lying open for inspection at the master's office for a period of 21 days. After those 21 days have lapsed, the master will then confirm whether they have or have not received any objections to the liquidation and distribution account, and then we will be able to distribute accordingly.
Okay, and then once distributed, are there any steps required to finalize the estate from the executor's perspective?
Yes, so then we have to file with the master proof that all the beneficiaries have been paid, all the creditors have been paid, and of course SARS is never left out, so we have to get a deceased estate compliance certificate from SARS as well. That is then filed with the master, like I said, and they will then ultimately issue a filing slip which says that we have then finalized the administration of the estate.
Okay, it sounds like there's a lot of third parties involved. Where can people expect delays in the process?
Well, Abner, you mentioned third parties, and that's exactly that. In order to administer and finalize the administration of the estate, we are dependent on information from third parties, and there can be a delay from other institutions. And also, the only thing that I can say or suggest is if the executor or the administrator asks the family for documents and information, is that they provide that as quickly as possible to prevent any unnecessary delays.
And then what should someone do if they have any other questions about this process?
Well, they're welcome to contact DKS. They can either contact myself or Abner, and we will be happy to assist.